In his 2011 book, Do the Work, Stephen Pressfield is trying to offer a guidebook for how procrastinating writers can finally finish their long form projects, whether that be the great American novel or just starting a new venture. He says that resistance is the internal, self sabotaging force that stops you from doing your work. That nagging sense to put off until I have more time, or until I've edited the memo again, or until I'm in a better mood to talk to this client. Of course, that exists in law offices, and it can be damaging to your reputation and to the client's interests. So, this is episode 3.2 in my lecture series, and once again, I'm your instructor, Roun McNeal. In this second lecture of a third unit, we will cover the duties of diligence and communication. I ended the last lecture by reminding you that maybe the most important aspect of complying with the duty of competence is simply doing the work. That theme and through line is generally true of the lawyer's duties of diligence and communication. Let's first look at the duty of diligence. Diligence is acting within the legally prescribed time or promptly responding to a client or party's request. Diligence is the opposite of procrastination. The American Bar Association Model Rule 1.3 says that attorneys must be reasonably prompt when representing a client. What exactly does reasonable mean, though? Well, any surface level study of tort law and negligence reveals that reasonable is an everyman standard that assumes similar levels of knowledge and experience. If a reasonable person would not have waited a week to file the lawsuit, then a lawyer who does wait a week to file the lawsuit may have violated the duty of diligence. The duty of diligence is most often implicated when an attorney's unreasonable delay causes some kind of consequence. An attorney that closes home loans might cost his client money if he delays the closing of the deal. The delay might cost the buyer a day's pay because they took off on Wednesday, anticipating that everything would be ready to go. Or in extreme cases, it might cost the buyer thousands because during the delay, the bank changes the rate on the loan. A nightmare scenario for a personal injury lawyer is waiting too late to file the lawsuit and inadvertently allowing the statute of limitations to expire. A statute of limitations is a time limit between finding out about the injury and filing the lawsuit. So if a person or her lawyer waits too long to file a personal injury lawsuit, it might be dismissed entirely. Sometimes a lack of diligence leads to a finding of pervasive neglect. That level at which lack of diligence becomes pervasive neglect is discussed in a 1990 case, Attorney Grievance Commission of Maryland versus Ficker. I emphasize the 1990 because it was the first of 5 complaints brought by the Maryland Bar against Robert Ficker. His office was chaos. Ficker was trying between 750 and 850 cases a year, mostly serious traffic violations like DUIs, out of 3 offices with minimal support staff and no organized case management system. Here are the details of one former client. Stuart Schultz was charged with DUI but maintained that he had nothing to drink. Schultz paid Ficker $300 on a $750 retainer fee. Schultz apparently never reviewed the case file until the morning of the trial. Ficker failed to interview or get any statements from key witnesses, including the police officers. Ficker was even unaware that his client had refused to take a breathalyzer. He also completely failed to keep track of the case, missing a plea conference meeting and failing to return multiple phone calls from the client's wife. The court specifically found that Ficker had no system for tracking the case, leading him to completely ignore it for months preceding the court date. The court also noted that Ficker's only support staff was an elderly man in his 70s who, after a subsequent stroke, was unable to even remember key details about Ficker's practice. Diligence is perhaps where paralegals can best demonstrate their utility in the office. Most lawyers want a paralegal who is very organized and on task. Lack of organization is the most common reason a lawyer might not diligently pursue a claim. He simply lets it slip away from the forefront of his mind. So organized paralegals are indispensable. Some tools paralegals can use to ensure diligence are master calendars that show trial dates and deadlines, just as the dates that statutes of limitations will pass on each claim the lawyer is handling. On a related note, paralegals might keep individual calendars for each office staff member, showing which tasks and deadlines are upcoming for each individual staff member. Many law offices also maintain a tickler file system. The tickler file systems are similar to calendars. Each date has its own folder in which you organize paperwork involved with a particular task that has a deadline. So if a complaint is due to be filed on October 30th, a good paralegal might file a copy of the complaint in the October 15 tickler file as a reminder that the deadline is upcoming. Finally, as we will discuss more thoroughly as we look through the duty of communication, it may be a good policy to set reminders to periodically evaluate each client's file with such frequency as is appropriate for that client's circumstances. Now that dovetails nicely into our discussion of the duty of communication. The duty of communication is the obligation of an attorney to keep his client informed of the status of the matter and to respond promptly to the client's requests for information in a candid manner. Remember that as the principal, the client owns the matter. The client gets to dictate the goals and objectives of the representation, and the client will be unable to do so if the lawyer does not effectively communicate with her. Mississippi Rule of Professional Conduct 1.4 explains the duty of communication in two parts. First, it says that a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. It further requires that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. This means a lawyer has both a duty to tell the client what is happening in the representation and a duty to make reasonable efforts to ensure that the client understands what is happening. Paralegals can provide assistance in complying with the duty of communication. The National Association for Legal Assistance Guideline Number 5 outlines the tasks which a paralegal may perform under the supervision of the attorney. In the realm of communication, this can include conducting client interviews and maintaining general contact. An example of general contact might be regular phone calls to update the client. It is important, though, that when the paralegal is fulfilling some of the lawyer's duties of communication, that the client is always aware of the status and function of the paralegal. The client needs to know that she is speaking to someone who is under the supervision of her attorney. In addition to regular contact, the duty of communication requires prompt contact when something important happens in a case that requires the guidance of the client. Let's examine another case. In re Sami. In this case, an attorney representing an auto accident victim lost contact with the client. As part of the case, the client needed to set up a medical exam with the insurance company, but the lawyer could not contact the client. Fearing that the case might be dismissed if the lawyer could not get the client to show up for the exam, the lawyer sent a demand letter to the insurance company for $5,000. The insurance company settled for $2,000, and the lawyer accepted that settlement without consulting the client. What are the takeaways from this case? Well, first, there is a question about whether the lawyer violated his duty of communication. That probably depends on whether he did something or failed to do something that caused him to lose contact with the client. But nevertheless, he was unable to contact his client. So when he accepted the settlement without communicating with the client, he deprived the client of his role as principal, or the person who directs the goals and objectives of the representation. The attorney in re Sami was suspended for 18 months for taking away that right of the client. While paralegals can assist with the duty of communication, a lawyer is not permitted to pass off this duty entirely. In People v. Milner, the attorney did just that. Milner's paralegal was permitted to have exclusive contact with the client. This failure came to light because the paralegal was lying to clients about the status of their cases. So in this case, Milner was violating both Rule 1.4, requiring communication with the client, and Rule 1.1, that requires competent supervision of support staff. Milner was disbarred. Some attorneys may use resources like a client relations checklist that help to practically apply the duties of diligence and communication. Such checklists are easy to find on the internet, or even in textbooks or through the bar, and may suggest items such as returning phone calls within 48 hours, sending follow up letters after meetings in which decisions are reached, and following up with clients at least every 6 weeks on inactive cases. Let's engage in some remote Socratic instruction. I'm going to present a hypothetical, the kind that you might expect to see on a law school exam. Here's an opportunity to put the rules and case examples to work. Imagine Albert Attorney. This is a lawyer who has a heavy caseload. He's instructed his paralegal to prepare 7 new bankruptcy petitions, 4 new wills, and 5 new complaints, and file all of them with the court. He instructs his secretary to contact the clients. In each of these cases, one client has called back several times, and the paralegal has answered the questions that he has, but the client wants to speak to Albert. Otherwise, things are running smoothly. Ask yourself, does Albert have a problem? Is his paralegal acting ethically? Is Albert acting ethically? The next and final lecture in this unit will deal with legal malpractice. We've only scratched the surface of the ethical duties of lawyers. There are many more in subsequent lectures. Legal malpractice is one potential consequence of violating ethical duties. So understanding legal malpractice now will assist in understanding later what the outcome of an ethical violation might be.